I am that I am, the divine trust, A-Bay, expressed as Land Air Water Bureau. I want to welcome you and yours to today's presentation. Today is 13/06/916, commonly known as June 4th, 2019. It is 2119 Prime Meridian, and today's presentation is called The Two Secret Oaths of United States Judges. That's right, brothers and sisters. There are two oaths that are taken. So we're going to get right into it. And we have accessed the oaths of office of the recent Associate Judge of the Supreme Court, Brett Kavanaugh. And we're going to get right into it. Here is his oaths of office. And let's look at the two types of judges there are. There are administrative judges and there are judicial judges, and they have different pay rates. The administrative judges get paid significantly less than the judicial judges, which is to insinuate that the judicial judges have more precedent than the administrative law judges. So here it is. Supreme Court of the United States, October term 2018. I, Brett M. Kavanaugh, do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. Brett M. Kavanaugh, subscribed and sworn to before me this 6th day of October 2018. Chief Justice of the United States. I'm not sure what that says. So, the signature anyway. So, nothing too out of the ordinary there. So here's where you find it in the United States Code, 5 U.S.C. Section 3331, Oath of Office. Same language. Same language. So then, here is the second oath. Some may say, why would they have to take two oaths? Well, there are two different types of persons being dealt with in the courts. So let's do it. Supreme Court of the United States, October term 2018. I, Brett M. Kavanaugh, do solemnly swear that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as Associate Justice of the Supreme Court of the United States under the Constitution and laws of the United States. So help me God. Brett M. Kavanaugh, subscribed and sworn to before me this 6th day of October 2018, Associate Justice of the Supreme Court. And here's where you find it in the code. 28 U.S.C. Section 453, Oaths of Justices and Judges. Same language. So what stands out here, brothers and sisters? This is different than the language expressed in the previous oath. Same justice, two oaths going on. He's the same person. So obviously, there are two different types of persons that come before him in delegating his office as Associate Judge of the Supreme Court. So let's break this down. It says here that Brett Kavanaugh solemnly swears that he will administer justice. So let's look at administer. This is Black's Law Dictionary, second edition. And the definition is to discharge the duties of an office, to take charge of business. That's right, it's business being taken charge of, to manage affairs, to serve in the conduct of affairs, in the application of things to their uses, to settle and distribute the estate of a decedent. Of a decedent. That's right. What is a decedent? A decedent is a deceased person, one who has lately died. Etymologically, the word denotes a person who is dying, but it has come to be used in law as signifying any defunct person, testate or intestate, but always with reference to the settlement of his estate or the execution of his will. So that means if you do not have a nationality, if you are not alive, you are dead before the court. Civil little more tus, an artificial person before the court. So they have to have an oath for artificial persons and an oath for natural persons. And this oath, the second of the two, is administered without respect to persons. And without respect means regardless, which means irrespective, which means despite, in spite of, regardless of, without reference, without respect or regard to, which means without attention paid to. So it's being said that justice will be administered regardless to the persons, to the artificial persons, and do equal right to the poor and to the rich. So this is saying if it's dealing in poor and rich, it's dealing in commerce. So this is the commercial side of personage. This is for corporations, artificial persons, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as Associate Justice of the Supreme Court of the United States under the Constitution and laws of the United States. So this is specifically dealing with juridical persons, which is an entity as a firm that is not a single natural person as a human being, authorized by law with duties and rights, recognized as a legal authority having distinct identity, a legal personality, also known as artificial person, juridical person, juristic person, or legal person, also referred to body corporate. So let's look at artificial person, a non-human entity that is created by law and is legally different, owning its own rights and duties. Non-human entity. Referred to body corporate. So let's look at body corporate. It's a corporation. So he has to have a separate oath for juridical persons, artificial persons, non-human entities. So what is an entity? Legally equal to a person who might owe taxes, a generic term inclusive of person, partnership, organization, or business. An entity can be legally bound. An entity is uniquely identifiable from any other entity. So here it is, we're dealing with Article 3 of the Constitution judges, and we're dealing with Article 1 administrative justices. So courts that have been established under Article 3 of the Constitution, including the Supreme Court of the United States Courts of Appeals, and United States District Courts, are called constitutional or Article 3 courts. This is dealing with human beings, Homo sapiens. Article 3 of the United States Constitution establishes the judicial power of the federal government. The Supreme Court of the United States was created by Section 1, Article 3 of the Constitution. Its jurisdiction is set out by statute in Title 28 of the U.S. Code. Under the Constitution, the authority of the federal judiciary extends only to certain cases and controversies, in quotes, which are identified by either the nature of the suit or the parties involved. So depending upon the nature of the suit or the parties involved, the parties involved are either going to be artificial or natural persons. The Constitution establishes that the Supreme Court of the United States permits Congress to establish inferior federal courts. The federal judiciary currently consists of the Supreme Court, courts of appeals in 12 regional judicial circuits, 2 intermediate appellate courts with special power to hear cases originating nationwide, a total of 94 judicial districts throughout the 50 states that contain at least 1 federal district court, 1 bankruptcy court, territorial courts that function as district courts in several territories, and specialized tribunals that have been established by Congress pursuant to power provided in Article 1 of the Constitution. The district courts serve as the trial courts in the federal system, while the courts of appeals serve as intermediate appellate courts. Under Article 3 of the Constitution, United States Supreme Court justices have lifetime tenure in their positions during time of good behavior. Lifetime tenure is also true of the judges in the lower constitutional courts of the federal system. Article 3 of the Constitution provides that a federal court may hear a controversy between citizens of different states or citizens of the United States and citizens of foreign nations. Congress in Title 28 of the United States Codes limits this power by requiring that the amount in controversy exceeds $75,000. The broad purpose behind diversity jurisdiction is that a state court may show bias towards its own citizen to the detriment of the citizen from another state. So let's look at administrative law judge. An administrative law judge is an official who presides at an administrative hearing to resolve disputes between a government agency and someone affected by a decision or action of that agency. Generally, decisions made by an administrative law judge can be reviewed by the filing of a request for review. When an administrative law judge renders a decision called an administrative order, it may be reviewed by either a higher level within the agency or by a real court, or it says a court. Real court meaning Article 3 court dealing with natural persons. A person denied their claim by an administrative law judge must exhaust his or her administrative remedies. That means take every step, including appeals, with the agency and its system before the administrative ruling may be appealed by a lawsuit in court. So it says here, administrative law. Branch of law governing the creation and operation of administrative agencies. Of special importance are the powers granted to administrative agencies, the substantive rules that such agencies take, and the legal relationships between such agencies, other governmental bodies, and the public at large. Administrative law encompasses laws and legal principles governing the administration and regulation of governmental agencies, both federal and state. Agencies are delegated power by Congress, or in the case of a state agency, by the state legislature, to act as agencies responsible for carrying out certain prerogative of the Congress. Agencies are created through their own organic statutes, which establish new laws, and doing so creates the respective agencies to interpret, administer, and enforce those laws. Generally, administrative agencies are created to protect a public interest rather than to vindicate private rights. So let's look at this word vindicate, which means to clear someone of blame or suspicion. So private rights are vindicated through Article 3 courts, not through administrative courts. So private rights deal in natural persons in Article 3 courts, not administrative courts. Statutory regulation of agencies. The enormous powers, the governmental agencies must still act within constitutional and statutory parameters. These and other limits have been codified for the most part into the overall statute known as the Administrative Procedure Act and state analogs, which provides for the roles and powers of all the agencies and the procedures by which they must abide by in their functions. The Administrative Procedure Act categorizes administrative functions into formal and informal rulemaking and adjudication, which have binding effects, as well as guidance, which has no binding effect. The APA further describes certain procedural rules by which the agencies need to follow before acting in one of the functions listed. So here it is. These administrative agencies are governed by the Administrative Procedures Act. For those who wish to know more in regards to what's governing these administrative courts that were authorized by Congress for juridic, artificial, colorable persons. So ideally, one would want to be on the natural person, Article 3, judicial side of the court. Here's a chart that breaks it down. So there are two types of courts delegated. Article 1, legislative branch, pursuant to Section 8, Clause 17, which is to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may by cession of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. So this is where the name in all caps, or the legal fiction, corporate, juridical, and legis person is on the side of the court, where you deal in statutes, codes, and ordinances. And here also, pursuant to 28 U.S.C. Section 3002, United States means a federal corporation. Also, pursuant to UCC, Uniform Commercial Code, Section 9-307, the United States is located in the District of Columbia. And then, pursuant to the District of Columbia Act of 1871, the municipal legislative power of the legislative district shall extend to all rightful subjects of legislation within said district. And then from there is derived the Constitution of the United States of America, which deals in administrative law for the municipal federal United States, where you find statutes, codes, ordinances, rules, and regulations for corporations, executive and judicial power over administrative agencies by Article 1 judges or administrators. This is the colorable jurisdiction for colorable, artificial, juridic persons, corporate fictions, and is not bound by the requirements and protections of living people protected by Article 3, Section 2, and the Bill of Rights. Also, on Article 2, Section 2 of the Constitution of the United States of America, it granted the President the executive power of Commander-in-Chief over the military of the United States. So we, the people, with the protections of the Constitution for the United States, we deal here in the Article 3, which is the judicial branch. And this is pursuant to Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. And this is also pursuant to Section 2. The judicial power shall extend to all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers, and councils, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens, or subjects. And this is where the Bill of Rights for natural persons or people with the nationality are ensured of their inalienable, God-given liberties and rights for non-corporate Homo sapiens with the living soul. So once your status is corrected, there can be no presumption of any artificial personage, any confusion with you being artificial under the jurisdiction as a corporation, as an in legis, because your status and nationality is effectively established on the record, and it is always with you. So you can have all of your rights fully working for you, not be a surety for the debt, bondage of being an artificial juridic person. So there you have it, brothers and sisters. The two oaths of United States judges. That's right. It's two sides to the court dealing with the person, artificial or natural. So they have to have two oaths depending upon which type of matter comes before the court, which type of person comes before the court. So let me ask you this, brothers and sisters. What type of person are you? Are you artificial? Are you natural? Are you dead? Or are you alive? With that being said, we're going to wrap up today's presentation. If you need assistance with correcting your status, we are available here at Land, Air, Water Bureau. We have the process of establishing the correction of your nationality, the correction of your status throughout every system. It follows you everywhere you go in all databases, and it is working for you at all times. Thank you for checking us out today. Don't forget to like, share, and subscribe. With that being said, it's been a pleasure. Divine love to you and yours.